All right. Well, Mike said I should spend most of my time talking about news updates. And I'm sorry, tell me your name again. Wendy. You were the one, I think, who brought up the fact that it's mostly through the courts. The TABOR Committee was formed out of the remnants of the Amendment 59 campaign committee. We looked around, we said, one of the biggest mistakes activists ever made was saying, people of TABOR, we don't have to have a TABOR committee anymore. And yet we'd still see lots of new proposals to do away with TABOR, and each time we'd form a new committee and say, well, why don't we defeat this one, and then we'd go away. So we said, let's start this out as an advocacy group, and then we'll put this educational group onto the side. Well, it turns out that the foundation has been doing most of the heavy lifting because we've gotten involved in a lot of lawsuits. And the first one I want to talk to you about is Kerr versus Hickenlooper. This is an existential threat. What has happened is some current, Andy Kerr from Lakewood, state senator, and past, Norma Anderson, state legislators, and a bunch of other people have said Colorado should not have a taxpayer's Bill of Rights because we are guaranteed a Republican form of government, and this does not allow. You ready for this? I'm glad you're all sitting. TABOR takes away the core, I want to get this right, because it's so unbelievable. It deprives a legislature of the core ability to perform their legislative function. And so the theory is that the citizens have taken over too much, and they can't just impose taxes on you, which is what they want to do. So they have sued, not in state court, but in federal court, and that's unusual. They're saying to the federal system, we want you to declare our state constitutional provision unconstitutional under the U.S. Constitution, Article 4, Section 4, which guarantees a Republican form of government. I'm not going to go into the detail because I know none of you want to become an expert on Kerr versus Hickenlooper. But right now, this threat is the biggest thing that could go on in our state. At this point, we're only arguing about whether we should have a trial. And that makes sense. If you can imagine, here come the plaintiffs, they say we've got this theory, and then they go through all the deposition and the testimony and the hearings and all the rest, the trial, and come out at the other side, and through the appellate process, the U.S. Supreme Court says, what are you doing? You never should have heard this in the first place. It's not, Ellen, you need your pad again, justiciable. I think I said that right. It's non-justiciable is what we hope they will find. And that is that this isn't an item for the courts. The courts are not supposed to interpose themselves into matters of merely political issues. And so we're saying a whole bunch of kind of counter theories. Don't do this because they don't have standing. There's some other reasons. But it comes down to just saying, get real. You, courts, shouldn't even be part of this discussion. This is a purely political thing. Now, the loss, if we lose this round, which has gone from William Martinez, so a federal judge here in Denver, it's gone up to the 10th Circuit Court of Appeals and a panel. And when I heard the attorney review that, he said we couldn't have gotten a worse panel of 3 judges, found against us. We then asked for an en banc, or the Attorney General's office did, trying to defend this, to say we want the whole Court of Appeals to hear this. That was turned down. So now the next step is going to the U.S. Supreme Court and saying, see, this is terrible. Don't even let this happen. If we lose, then we go, if our side, the good guys lose, then we go through the trial. if, please say a prayer, the Supreme Court does the right thing and says, yeah, this never should be heard, then that kills the whole lawsuit. And the petition for certiorari, that's asking the Supreme Court, happened last fall. They took it up early January, so we should have heard something, or December. We were expecting to hear something by the latter part of January, because that's about the time it takes for the Supreme Court to say, yes, we'll hear it, or no, we won't. And it just keeps dragging on and on. The best answer I've gotten is from the attorney now in private practice who was working on this case for the AG's office. He said the reason they're doing this is an Arizona case. It has to do with redistricting. But the question will become much more clear, or the answer will become much more clear, of whether the federal government can interpose itself between the people and their constitution and get involved in a merely political thing. So now the best thinking from this attorney is they'll resolve this in June. We'll hear something in July or August. There's an important thing for you to worry about every day until this gets resolved. The plaintiffs say they're going after TABOR, but their theory is the citizens aren't allowing us to do our job. So we know in this room that a constitution is where the people tell the government how to behave. And throughout the nation, there are all kinds of limits on, somebody asked about the other tells, I think it was Brad, about the other tax limitations. But what about term limit limitations? What about marijuana items? Anything that has come through the initiative process could be subject to the same theory, which is citizens got involved instead of leaving it up to the legislators. And so you have then, if this proves out, if this wins, you're going to have this massive new theory about how America functions, which is you get to elect your dictators every 2 years, and they get to do anything they please because you citizens can't restrict them in your Constitution. And there are people across this nation going nuts over this lawsuit. The Attorney General is the defendant, and by the way, has done a very credible job, thoroughly professional. The TABOR Foundation is, if you will, the lead amicus. We have joined a whole bunch of people from across the nation, Goldwater Institute in Arizona, Citizens in Charge out of Washington. We're being represented by the same people who filed the lead attorneys against Obamacare. That's the NFIB, National Legal Headquarters. So we're traveling in some big circles for our tiny little TABOR committee, and I'm rather glad we are, because we want to be right there to talk about this terrible idea. So anybody mad yet? How about everybody stand up? Come on, stand up for about 10 seconds. Shake it out. You can stamp your foot. Yeah, so I said it's like trying to throw a bomb into a crowded marketplace, saying we're only going to kill one person. It's just not going to happen. This is terrible. So, enough with Kerr. I had you stand up so you'd be ready for the other few. We're also suing in the Bridge Enterprise Fund. Now, the Bridge Enterprise Fund is a foul, dishonest, words escape me, despicable, and historical embarrassment, a stain on the Colorado government, and certainly against any type of transparent good government. And the Bridge Enterprise Fund has already taken away from you the ability to say whether you want a new tax on repairing bridges, and it's about to put you a total of $1 billion in debt. Yeah, I wasn't misspeaking. $1 billion in debt, and you're never going to get to vote on it. Now, here's the fiction. All right? Scott, when you go home, the fiction is you're going to drive over a bridge and pay a toll. That's what this legislation says. And the toll shows up as a singular charge on your vehicle registration every year. Look for it. It's called the bridge surcharge. Now, it's a flat fee because they don't know how many times Dave goes over a bridge, but they're going to say he's paid a toll. Interestingly enough, if Dave's cousin from Montana drives over the same bridge, he doesn't pay the toll. And that's not, they say, oh, that's not a tax. So they take this charge, and do they give it to a government? No. The Taxpayers' Bill of Rights has this tiny carve-out called an enterprise. And it was intended for very limited sort of situations. The best example would be a college dormitory. So a college dormitory, you have the college issue a bond for this enterprise. The bond builds the dormitory. The students pay resident fees every semester to pay off the bonds and operate the place. And so you've got essentially a government business. But the Bridge Enterprise Fund was set up in the Department of Transportation. It takes a historically common government service, repairing the bridges they've already built and owned, and it says, we will take these tolls that Scott and others have paid, and because we're an enterprise, we don't have to get your permission to bond. We just go do it. Now, the organization has a board of directors. It is identical to the Colorado Transportation Commission. It has an executive director who is identical to the executive director of Colorado Department of Transportation. It has a CFO. I mean, you just keep on going. It's located in the same place. So you have the Colorado Transportation Commission sitting around a table. At one point, chairman knocks on it, says, okay, we're no longer the Colorado Transportation Commission. We are the Bridge Enterprise Fund. Let's keep doing our business. And that's literally what they've done. Now, in this bizarre, terrible, I should have people throwing things by now. In this bad deal, the courts have decided that that is truly a fee that you pay. We made the point in our lawsuit that if you're going to do that, that is, you're going to have a fee, then that fee should only be paid by those to whom it applies. So yeah, okay, you're going to put some bridges in Boulder. How can you, therefore Scott's going to pay? But what we went around and found 29 counties and people in those counties who had vehicles that never left those counties, and none of the bridges were being repaired in their county. So a wonderful, courageous person named Chris Salmons up in Grand County said, yeah, we got a vehicle. Doesn't leave the ranch, and when it does, it just goes into town and back. And we found another guy, Willie Wharton, who said, yeah, I plow my elderly neighbor's driveway, but other than that, it really never leaves here. But he pays the bridge surcharge. So how can you possibly justify this? And this was in Denver District Court, so a Colorado court system. And Michael Martinez said, I don't know why not, and ruled against us. Then we went to the Court of Appeals and we said, you've got to be kidding me. Isn't this terrible? And the Court of Appeals said, nah, we think, if nothing else, it's anticipatory. That is, at some point, we can charge you this fee because at some point you might use it. So literally, our attorney came back and said, but that would allow a university to charge a fee of everybody on the theory that maybe your kid or your grandchild at some point might go to that university. Anticipatory. Yeah. Well. So, and there are other problems with it. You can't, if you're an enterprise, you can't have more than 10% of your income come from tax subsidies. But when you give a bridge to the Bridge Enterprise Fund, and of course that's just a paperwork effort as it goes from one end of the hall to the other, you've given more value, and it still didn't stop. So all of our efforts there are waiting on our Supreme Court to see if they'll take it. And if they weren't backed up, we should have heard some time ago. So every Monday, because once Mondays are over, then we have to wait till the next Monday, the court announces what it'll take, and it hasn't announced ours. There are three other things that I'm going to go through fast, and then Bill's going to ask a question. The General Assembly said to RTD, which is a separate government, by the way, said, you can go ahead and tax people on these items you haven't been taxing before, cigarettes and some sodas, and make it align with the state. Okay, could have been easier on people who collect the tax for the state government. But the rule says, if you're a government, once you've been given permission by the state, in this case, for a regional government, you can go ahead and ask people to do that. They said, nah, we've got the permission of the General Assembly. What do we need you people for? And they just imposed the new tax, and it raised revenue. So even if they claim it was just a change in fiscal policy, the net result, the revenue went up. We're suing them. Just within the last couple weeks, we lost that at trial court. Is there any good judge out there?
Have you ever won anything?
Larry, you're hurting me.
I didn't mean it personally.
The Colorado Union of Taxpayers is suing the town of Aspen, which said, we don't like people taking plastic bags away from grocery stores, so we're going to tax them until they stop. But they called it a fee. Back to you, Whitney. They called it a fee. And therefore, Aspen right now is collecting a bag fee. Colorado Union of Taxpayers is suing. We'll see how that goes. And then the other thing that we got involved with tangentially, but we're not the plaintiff, is the Gaylord Convention Center. So here's a 1,500 room place that's being built with $300 million of subsidies from the city of Aurora, $80 million from the state of Colorado, because after all, what developer should be made to actually pay for the stuff he builds? I can't even get past the corporate welfare thing. If you look in the Citizens Budget, I was happily the lead author for that. It's on the Independence Institute website. We have a whole chapter on getting rid of corporate welfare. This is just wrong from the start, that Stu and Ted might be able to better understand how you guys should be investing than, say, investors. And that by being in government, they're going to steer money to these favored people. That's just wrong. But then, to make it work, the city of Aurora had a TABOR election. They carved out a piece of this, and they said, that little area where remember, this is going out on a prairie. It's been blighted because it's open prairie. They said that little area of Aurora is just a taxing augmentate. We're going to augment the taxes there. It's just a little taxing district on top of that. Now, there's one owner of that property. So they had the one owner do the TABOR vote. Amazingly, it passed. But understand how this is so dishonest, because under the Taxpayers' Bill of Rights, remember we say you take the last year's budget and you can increment that? Well, the city of Aurora, with all these subsidies over 30 years, is just going to have this stream of income that has to be met under the total budget. And the people of Aurora don't get to vote on it. Only the one guy in the taxing district, but it affects the entire budget. So we hope that Gaylord, by the way, that one, Larry, was won. It's only a trial. It's under appeal, I'm sure, or will be. But that one was won so far. So, Bill, you had a question.
You're familiar with the hospital provider
charge fee?
Yeah, and that's a lot of money. Did that fee raise the revenue of the state enough to where it's actually going to trigger a TABOR? Can fees trigger TABOR? Because this one's a big one.
Yes. And it has held up the base then. What's not under the state's TABOR formula is the money from the feds. And why the Hospital Association loves this and the doctors love it, and therefore the legislators love it, is it's all matched by the federal government, and that goes to the uncompensated care. So people who have no money, they walk into a hospital ER room, they say, you got to take care of me, the law says so. We pay for it in part through our federal taxes and in part through this fee, this charge. The reason I wanted Bill to ask me about that is that's our next, at this point, this is our new project that the TABOR Foundation is working on. There was a memo that came out of the people, legislative legal services, who work in the Capitol and who tell the legislators whether things are going to be constitutional or unconstitutional if they ask. Otherwise, it's just presumed that anything the legislature does is constitutional. Presumption. They said, well, under all of these old court cases, you probably can get away with that as long as it stays in that particular stream. It goes as a match to the government. It gets used only for this uncompensated care. I certainly would argue with that, but they were saying you could probably get away with it based on precedent, but never put it into the general fund, never put it into the stream of general government expenses, or it will become a tax and you will not have had a TABOR vote and you'll be in trouble. There were 2 bills that affected 3 years in which they raided that fund, moved the money into general government expenses, and said, well, let's see if anyone catches us. Well, I just found out about it. It was 3 years ago. They stopped it since. But we've already had a meeting with the Hickenlooper administration. I've already had a conversation with the senator who's the chairman of the committee that would hear anything about this. So we're starting. Bill, just push the snowball off the top of the hill and hope it'll keep on rolling. We'll see. It's terrible that they do this.
And it's a secret. That's the extra terrible.
Oh, yeah. And by law, the hospital can't say that it's charged you or your insurance company. So you see, the fight here should be on several different levels. We're a tiny group of people. We need your help to keep going. And furthermore, we want to be proactive. We want to get people active on stuff that, Larry, I know you're busy enough, that actually moves back what all these depredations we've heard about. So if you're not going to volunteer, don't take one. I only put out about 20. I'm also going to ask that if you want to hear from us so that you get updates and I don't have to put you to sleep at these meetings, sign up and Dana West will put you on a blast email and you'll get the newsletters that we do. And that is as long as I'm going to talk to you. And Mike, unless there are more questions?
Please.
Oh, okay.
I thought of one. So I'm very sympathetic to the notion that exempting fees is a very bad idea because I'm from California. And they just upped every fee they could to get around Prop 13. It occurs to me the argument you said they used that, they don't want people having to vote on, like, towel fees. So wouldn't it be possible to do a constitutional amendment limiting fees where it would go either by the actual dollar amount of the fee itself or the total amount of revenue it was raising?
Well, yes, and that's one of the options. We have a board member who is pushing for us to make that a big initiative, literally put it on the ballot. The way we're talking about doing that, if we ever do it, is more defining what a fee is, because that has broader implications throughout the state budget.
Right.
But we would define what a fee is and what it is not, so they couldn't keep monkeying with the definition. And right now, it's one voice, one board member saying we need to do this. We all agree with them. And we say, well, how are you going to get that done? It's Brian Vanderkroll. If you know Brian, he's on our board. And he's got a great idea. And right now we don't have the resources to even start it. It would take supposedly $400,000, what you pay to get an initiative through. You need to obtain 120,000 signatures. That's as much as half of the cost. And then you probably need multiples of that because you know the bad guys are going to come out of the woodwork and say, well, if you define this as a tax instead of a fee, well, we won't get our cut. We won't get our stream of revenue. And we'll have everybody after us from the hospitals to the Colorado Department of Transportation to the, you name it. All right, well, I hope I got discussion happening, and I hope I got people mad. Thank you very much.